basically break my presentation up into two parts. First was I was going to give a thumbnail sketch of generally what types of areas of practice that we're involved in, and the second part just open it up to questions, because usually those run a little bit longer. At least that's been my experience in presentations. What our firm primarily is engaged in is in general practice, which means we cover a wide spectrum of things. We do collections for individuals and businesses. If somebody owes you money and they don't pay up and you want to file a lawsuit against them, that's something that we would do. In Wisconsin, there are two types of lawsuits in civil courts. There's small claims court, which is any amount in dispute that's under $10,000, and large claims, which is formal civil procedure, which is a claim that's over $10,000. It used to be $5,000, but July 1st of this year it was raised up to $10,000, and it had been at about $5,000, I think, for about 15 years prior to that. Basically, small claims court is an informal court procedure. I know the commissioners and the judges loathe to say that it's not people's court. Well, it sort of is. If you've ever been to small claims court, that's what it kind of turns into. In small claims court, the commissioners or the judges are not bound to follow the rules of civil procedure as stringently as they would in large claims court. But if there's an attorney representing a party in there, if they make an objection and it's a valid objection as to a form of question or something that somebody's trying to introduce, the commissioner or the judge will sustain that objection and will not allow that evidence into consideration. The difference basically between large claims court and small claims court is that in large claims court they do follow formal rules of civil procedure. It's also a lot more lengthy in time. Small claims court in Milwaukee County, in general, if you file a lawsuit, your first initial appearance will be within 30 days. And that's the first time that you appear in front of the court. If the other party doesn't show up, they'll grant you a judgment. If they do show up, you'll see the commissioner for about 5 minutes or so. They'll see if you can reach a resolution. If not, then they'll set it for a formal hearing, and then you'll have your day in court, and it's usually in about, I'd have to say, 90 days or so. And then that's the date that you actually go in front of the commissioner and you bring all your witnesses and your physical evidence, and you have your day in court. And then the commissioner will render a judgment, and there's chances to appeal, but I'm not going to get into that. Large claims court, on the other hand, if you have a lawsuit that's going to go all the way to trial, you can pretty much anticipate that it's going to take about a year to 2 years to actually get in front of a judge or a jury. The thing with litigation is it's expensive and cumbersome, especially in large claims court. I've gone to mediation numerous times. We've used a mediator by the name of Patrick Snyder, who was a judge out in Waukesha County. And Pat Snyder basically, when the two parties are there at the same time, his statement is ask your lawyers how much this is going to cost you, then double or triple it, because that's about how much it's going to end up costing you. It's very expensive. It can get to be, depending on how much time an attorney has to devote to it, it can get very, very expensive and very, very quick, because a lot of people think that what they want to introduce that evidence in trial is very important when it actually isn't. That's what you're paying us to figure out. Our firm also handles traffic matters for people. Gotta warn you, it's holiday season. The Sheriff's Department, and especially Milwaukee County, has stepped up patrols. So they're going to be out on the highways tagging you for speeding or anything else that they can get you on. Basically, if you do get a ticket, I can be your ticket fairy and fix it to be a little bit of a lesser charge. Milwaukee County is extremely generous with their offers, but you got to pay a little bit more. They'll turn a speeding ticket up to 20 miles over magically into a parking ticket if you're willing to shell out an extra $100, $150 for that, which you know, for your insurance rates, it's probably best to have a parking ticket versus having a 20 mile per over speeding ticket.
Just a little heads up on a 20 mile an hour over speeding ticket, sticks with you for 5 years. It's like a DUI.
Yep, and it's a 6-point violation also. So, also handle in traffic matters if people have had too much to drink and they have a problem with that, get thrown into jail. OWIs, operating after revocation, those types of things. We also set up corporate entities if you want to incorporate as a corporation or an LLC. That's advisable for any small business. You have to, as a corporation, you have to have your bylaws set up. As an LLC, you have to have a membership agreement drawn up. A lot of people think that, you know, I'll just go to the website and register my corporation. Well, that's fine and dandy. You're registered with the state of Wisconsin, but as far as the law is concerned, if you're not following corporate procedures, do not have yearly meetings, do not follow the things that are in your bylaws, if you don't even have a set of bylaws, as an attorney that would be representing a person against you, you not having those things, my argument would be is that you're in fact a phony corporation. You're not operating as a corporation. You're not following the legal procedures that you have to follow to be a corporation, and I would be asking the court to basically hold you individually and personally liable because you aren't a corporation because you're not operating as a corporation. You also, as a corporation, have to have separate books. You can't commingle funds. It's a lot of people operate their corporation as their own personal bank account or kitty. Those are certain things you got to watch out for. Other areas of practice, we do criminal defense. Just had a guy that got pulled over and he had a firearm, a Glock pistol that he had bought at a gun show. Turns out it was stolen. DA was looking to charge him with a possession of stolen property. Was able to negotiate with the DA to have the matter dismissed after showing him the receipt and all those types of things and explaining to him that, you know, he had no clue that it was a stolen item. I also do a lot of evictions for landlords, and a few times I represent tenants and sue landlords that are bad landlords. Do contract reviews. Sometimes people just want me to take a look at a contract. Same thing with real estate. Usually it's not worth it for you to pay me to sit at a closing, but if you want me to, I'll be more than happy to do that. Do a limited amount of personal injury if somebody's been injured in an auto accident. If it's something that's a little bit more serious, I have a few attorneys that I have referred clients of our firm to that have done just wonderful jobs for our clients, and everybody's been happy about that. So. Not a large focus of my business. I don't have advertisements up, you know, with a simple phone number 333-333, you know, if you fell down and want to blame somebody else. Another area is basically divorce work. You know, families break, you know, people get divorced. We do represent people in those areas. So that's a thumbnail sketch of the types of areas that we practice in. So anybody got any questions they want to ask, either specific or just, you know, any general? Yes?
Small claims court.
Yes, sir.
Sometimes, it seems to me that sometimes you may get a judgment, you may never see a dime. So it's like, why bother?
Well, basically, anytime that we do a collection matter, my first question to the client is, do you think you can collect on it? Are you going to throw what's said good money after bad? Mm-hmm. I don't know this person. I don't even have a relationship with them. You know, if we're gonna embark on trying to do a collection, the first thing you should assess is whether or not, you know, they're a constant deadbeat. You know, you can. I mean, I can look on CCAP and see how many judgments somebody has against them, and if they have numerous judgments against them, you're just getting in line behind everybody else, and it's probably not worth, you know, pursuing that matter. And I mean, our firm has been in operation for 15 years, and I've got cabinets full of judgments. Mm-hmm. It's a rare occasion that you get a call from a title company saying, you know, so-and-so that you did a lawsuit against 7 years ago, you got a judgment against them, what is it going to take to get rid of it, you know? Mm-hmm. I mean, I can count those on two hands over the 15 years where that's happening. Generally, I mean, if they have a good job, you can garnish their wages. But you have to know who their employer is. You don't want to sue somebody that's working at, not to malign the line of work, but if they're working a minimum wage job, because if you ding their paycheck, you'll probably be able to do that once, and they'll just quit and move from, let's say they're working at McDonald's, they'll go work at Burger King next, And the employer, they have a duty to withhold above the poverty level, 20% of their wages that are available for garnishment. But then you run into other situations where if they're divorced, child support takes precedence over anybody else. If the government's got, their claws into them for tax warrants or things like that. It's a question of whether or not it's worth devoting the time, the effort, the energy to go after somebody, because the only thing that we get for you is a piece of paper that says they owe you X amount of dollars. Now, they can't buy real estate without satisfying a debt because no bank is going to loan to somebody that has outstanding judgments against them. But again, if you sue somebody that has a common name, there's no way that a bank will know if, John Smith, that, a judgment against a John Smith, good luck figuring out if that's the person. The title companies usually on those, they'll just have somebody sign an affidavit that that's not their judgment. They can lie on the affidavit, but but that's one thing you have to consider any time that you're going to get involved in litigation is you're wasting your time too. You're going to have to go to court. As attorneys, sometimes people say, well, can't you just introduce the evidence, my bill and things like that? No, we're not allowed to testify. We have no way there's no foundation. I didn't do the work. I don't know what this bill is for. I don't know what the services were provided. Any of those items, you have to actually have an employee or yourself come down to court to testify. Tell the judge that this is what the services was for, that it was a reasonable amount that you charged, and that they owe you that amount of money. Yes, Ron?
How do you translate that into if you're taking another business small claims court? Is there more leverage there as long as the business is ongoing?
Well, yes and no. I mean, basically, if you know that the other business has a bank account, you can garnish, it's called a non-earnings garnishment. You can garnish their bank account. You have to know that they have money in the bank account because you're going to be spending roughly about $150 to do a non-earnings garnishment. That's for the legal forms from the clerk of court, plus you have to have a processor to go serve the bank. The difference between an individual and corporation is an individual is allowed to have $1,000, up to $1,000 in their bank account before the bank has to set aside funds for the garnishment. In a business setting, any amount of money that's in that bank, you can ding that bank account, and the bank that the garnishment order was served on will hold that funds until the court says to turn it over to you. So it just depends. I mean, you can have a business, that they've got $200 in their checking account. You're pretty much going to spend $150 to get $50. I mean, you get your $150 back, but unless if they have a beginning of the month, if they're like involved in rentals or stuff like that, most of the rents are coming in. That's a good time to nail the bank account. I mean, there's all sorts of tricks involved, but again, it's a question of whether or not it's a viable business. Unfortunately, these days, I mean, it's hard to tell. I mean, if you have your doors open and your lights on, you got to think that at least they're, treading water in this economy. But it's hard to tell if they, in fact, have a lot of money in a bank account or not. There's just no way to find out. Yes, sir.
In a large claims action, how important is it to have an expert witness? What I'm getting at is, let's say that somebody came in and did work for me, and it was shoddy, and it's not what it should be. Can I go in with pictures to say this is what I expected, or this is just not adequate, or whatever? How important?
No,
is it?
you're in that particular case, I would say that you're probably the judge is gonna require that you have an expert witness that can testify to the workmanship, why the particular product is shoddy, because basically attorneys and judges, we're not the smartest people in the world, not the sharpest tools in the shed. But basically, the rules of civil procedure require an expert witness to testify to anything that would be beyond the normal general knowledge of anybody in the public. Now, you could have a judge that's sitting on the bench that used to be a former contractor, but unless he's wants to assert his role as being, the Mr. Contractor or something which is extremely rare, you're going to have an expert come in there and testify to him. And if it's in front of a jury, obviously the jury, you don't know who's going to be sitting on the jury. They have no idea what standard construction practices are, what needs to be done, what's done properly, what's done improperly, what can pass off as being adequate work. Yeah, you're going to need an expert that comes in and testifies to that, which is another additional expense. I mean, you're going to have to pay that person to come into court and testify. And, a lot of times, I mean, I don't know what the statistics are, but usually in large claims court, at least the ones that I've heard bandied about, are between 90 and 97% of all cases settle before it goes to trial, or before actually a jury or a judge enters a verdict, because there are just so many unknowns out there that it's a zero-sum game. When the decision comes down, that's what it is. But in your particular case, yeah, I think you would need an expert. So, yes.
What are you looking at for minimum cost to file a small claims?
Small claims lawsuits, Milwaukee County is the most expensive. It's $99 to file. That's what you pay to the clerk of court. And then you're roughly paying around $30 to $35 to the process server to serve somebody. Yes, Drew?
This might not be up your alley, but all these things with these recalls and then the legal actions surrounding them and the cost of the taxpayers, do you have any, I'm confused how all that works. Okay, there are legal issues involved. Does that somehow get kicked back to the taxpayer in any way, or how does that all play out?
Oh, absolutely. Anything in politics, we all pay for in some way or another. As far as I know, I mean, I think the recalls themselves, I mean, the local jurisdictions, if they're going to be in effect, they have to bear the cost of the elections. Now, any of that, the lawsuit that was just filed in Waukesha County, I think it was the Republican Party that filed it. They're paying their attorneys to represent them there, and then any other group that's going to get involved or intervene in that type of group is paying for their own attorneys. Now you may have like the Attorney General's office, the state involved. That's being paid by the taxpayers. But as far as, I mean, I don't know how to answer your question. I mean, I don't know who's paying for what, but eventually, I mean, if a group brings an action, they're usually responsible for their own attorney's fees. Now, if the state's compelled to do something, obviously there's costs involved and the taxpayers are going to have to pay for it. So if the judge says that, and the judge can order attorney's fees to be assessed in cases too. It's extremely rare because the American system is basically each side pays their own attorney's fees. Unless it's written into a contract or something like that. I mean, a lot of times people say, well, can I get my attorney's fees paid for? Well, the short answer is no, you don't get your attorney's fees. Unless it's in a contract that you negotiated with the other party that specifically said and had a clause in there that said that the prevailing party's attorney's fees shall be paid by the losing party or some language along those lines. You're not going to get your attorney's fees. In small claims court, or in large claims court, you do get statutory attorney's fees, but I think the maximum on that is $500.
Will we ever have a loser pay law?
That's up for our wise people there in Madison and in Washington, D.C. to figure out.
More sense in the
Assuming there are wise people in those.
Passing judgment. Anybody else? Okay, all right, thank you.